Hey everybody, it's Jennifer with Get Your Credit Perfect Now, and in this video, I'm going to talk to you about what is a will versus what is a trust and how you can determine which one is going to be best for you and your family. Now, this is something that I'm really passionate about and I think is really, really important to talk about because not enough people are really making the necessary plans to make sure that their family is protected. I speak with a lot of people that are married and they automatically assume that property they own will transfer to their spouse without having to go through probate or any type of legal proceedings in order to complete that transfer. And that is not automatically the case. It really does vary and depend on how the property is vested and a number of other factors. What I want to just say is this. It is always best to have at least either a will or a trust in order so that you can not only just advise on where you would like for your assets to go, but also advise on what you would like to do with your minor children. Particularly if you're a single parent and you're the primary caretaker of your children, if you do not have a will, that can create an issue where your children will end up going to a family member or someone that maybe you would not like them to go to. So a will protect that type of situation. So what I'm going to do is talk to you a little bit about the definitions of each and provide you a few different examples of some advantages and disadvantages of each so you can determine which is going to be the best option for you. So let's just talk about what a will is. A will is a legally enforceable document stating how you want your affairs handled and assets distributed after you die. Again, if you have minor age children at home, a will can appoint guardianship of your children, at the time of your death. So again, you may have someone that is within the family that might want to take care of your children if something were to happen to you. However, if you do not have a will, that person may not get custody of your children because they have no instruction. It may go to another family member or associate or whatever that may be more, financially stable or whatever the case may be. If you don't have a specific instruction, that is something that can happen. So definitely a will is something that can protect you and your children from that type of situation taking place. Now let's talk about what a trust is. A trust is a fiduciary relationship in which you give another party authority to handle your assets for the benefit of a third party, your beneficiaries. So again, a trust is another method of estate transfer. A trust is created for a variety of functions, and there are many types of trusts. What I want to say to you is this: don't get overwhelmed or fixated on the whole terminology of estate transfer. If you own any type of property, you have an estate. So it doesn't mean that you have multiple millions of dollars or anything like that. If you own assets, then you have an estate. So so we'll talk about there's two different categories of trust. You have living and you have testamentary. A will can be used to create a testamentary trust. And again, I'm not going to go too deep into that definition. If you're curious, you can Google, what the definition of a testamentary trust. But the most popular and most common form of trust is a living revocable trust. Now, let's focus on a revocable living trust. Like a will, a trust will require you to transfer property after death to loved ones. It's called a living trust because it is created while the property owner or trustor is alive. It is revocable as it may be changed during the life of the trustor. So basically, this is saying that you as the individual, let's just say that you own a home, you own your primary residence right now, and you decide to put your property, title it into your trust. What that means is a couple of things. That means that in the event that you were to get in some type of accident, maybe somebody slipped and fell on your property. Maybe you got into a car accident or something like that. What happens in those instances is that attorneys do a public record search and determine if you own any type of property. And if they determine that you do own property, they will make that lawsuit against you much higher, because they know that you have assets that you can sell or liquidate in order to pay it. So what will happen is, when you put your property into a trust, the trust actually now owns your property. You are the beneficiary of the trust, so that means that you still have ownership of the trust. You have control over what happens to the property, but you don't have ownership. You don't have formal ownership. So that property cannot be looked up via public records and determined that it belongs to you. So it does provide a high level of asset protection, as well as a few other things that we'll talk about. So the beauty of having a trust as well is that it passes property really seamlessly without having to go through probate. So that means that you have no court fees, no attorney fees, nothing like that. After the trust is established, all assets can be transferred cleanly and effortlessly to the appropriate parties. So let's talk about considerations in determining if a will versus a trust is in your best interest. Let's talk about number 1, mental disability. Regardless of your net worth, and particularly if you have any assets which are titled in your sole name, you should consider a revocable living trust for mental disability planning. A well-drafted revocable living trust should contain provisions for determining your mental capacity outside of a court proceeding, as well as how to take care of you and your finances if you do become mentally incapacitated. So basically what this is saying is that, under normal circumstances without a trust document, if you were to, unfortunately, have Alzheimer's or dementia or something along those lines, you would need a court to step in and determine whether or not you are competent enough to manage your money, and who would then be responsible for managing your money. What this does is it allows you upfront to determine at what level you are deemed mentally incapable, and then who would be responsible for handling your affairs at that time. So it puts your power back in your hands instead of putting it into the court's hands to determine what is best for you. So let's talk about number 2, which is your minor beneficiaries. Often the largest asset that young parents have is either a life insurance policy or a retirement account, such as an IRA or 401k. It becomes a problem if the young parents later divorce and one of the parents want to name the minor children as the primary beneficiaries, or if both parents die while the children are still minors. What will happen to the life insurance or retirement account? These funds will generally be placed in a court-supervised guardianship for the benefit of the minor until the child reaches 18. In these situations, the parents should consider setting up a revocable living trust and naming the trust as the primary or contingent beneficiary of the life insurance or retirement account. So basically what it is saying here is that if you have children and you pass away without any type of will or trust, even if you have a will, basically what's going to happen is that the funds from that life insurance are going to go into a court-ordered guardianship account that is not going to be accessible to your children until they're 18. So in essence, if let's just say that like we're using the example of the divorced couple, you're no longer going to be having your husband as the beneficiary because you're divorced. So you want the proceeds to go to your children in the event that you pass away. If your children are under 18, that money is not accessible, which means it's not able to provide for living expenses for your children. So that is an issue because, again, if you have children that need to be taken care of, they have, you know, the expenses of taking care of children. If they go to now stay with their, you know, their grandmother, and the grandmother's retired, she's on a fixed income, if she's not put on as the beneficiary of those proceeds, she also cannot access those funds to take care of your children. What a trust will do is actually make it so that you can specifically outline the terms of how that money is distributed and to whom those funds will be distributed without having a court step in to determine that for you. So let's talk about number 3, single people. Anyone who is single and has assets titled in their sole name should consider a revocable living trust. The 2 main reasons are to keep you and your assets out of a court-supervised guardianship and to allow beneficiaries to avoid the costs and hassles of probate. Now, this is something to keep in mind when trying to differentiate between a will and a trust. The minimum net worth necessary for a single person to consider a revocable living trust will vary from state to state. For instance, in Florida, estates valued at $75,000 or less are considered small enough to be administered through a simple summary probate process. If the value of your assets is over the minimum threshold for your state, then a formal, time-consuming, and costly probate administration will be required instead. So that being said, if you are single and you have less than a certain amount of assets, what I would recommend is that you go on your particular state's websites and determine what is the legal threshold that you can make to have a simple to qualify for a simple summary probate. Otherwise, what's going to happen is that, you know, any types of debts, taxes, fees, whatever that you owe is going to be administered through the state, and they're going to, if necessary, sell any assets that you have in order to pay those items. So if you want, you know, your home or your business or whatever to go to your loved ones, you know, you definitely want to set up some type of trust to instruct that to happen. However, if you do not have over a certain amount of assets, it may not make sense to do that. At least having a will that outlines your wishes will be plenty in order to satisfy that requirement if you have under a certain amount of assets. Let's talk about married couples. If you're married and the estates of you and your spouse exceed federal estate tax exemption, which was $5.3 million in 2014, or your state's estate tax exemption, which can be as low as $675,000, then you should consider revocable living trust to take advantage of both spouses' exemptions from estate taxes. This is something that may not apply to you depending on how much, you know, what your actual net worth is. But again, it's not extremely difficult to acquire a certain level of net worth if you live in one of these high-priced housing markets, and have a high-priced home. However, again, you'll want to understand what the ramifications are for you, depending on your, the amount of assets that you have, whether or not you will be subject to estate taxes. If you are, then a revocable living trust will definitely help in that regard. Number 5, couples in second or later marriages. If you are in a second or later marriage and you and your spouse will have different beneficiaries, such as your children or grandchildren, then you should consider establishing a revocable living trust to ensure that each spouse's estate will go where he or she wants it to go outside of the probate process. I'm not going to get too deep into that, but what you should know is that with a will, if these things are not outlined in a certain way, the court can still mandate that assets go maybe where you did not want them to go. So that's something to keep in mind. Number 6, keeping your estate plan private. This is a huge one. when you go through probate, all the records of that process are public record. So literally, the amount of money that you have, the assets you have, where the money went, how the money is being allocated, all those things can be public record if you just go through the probate process, which generally happens if you just have a will. So having a revocable living trust will keep the details of any asset transfers or anything of that sort completely private from the public view. Now, number 7 is real estate located outside of your state. If you own real estate in more than one state, then you'll need to establish a revocable living trust and deed any of your out-of-state properties into that trust. Otherwise, your family may be faced with 2 separate probate estates, one in the state where you live and a second in the state where your real estate is located, which is referred to as ancillary probate. So in addition, probate can be a long, arduous process. In addition to having it in your primary state, if you don't have a trust, you can also be subject to probate in multiple other states. So also something to keep in mind. So the long and the short of it, based on, hopefully this information was enough to give you a better idea on whether or not a will or a trust is going to be right for you. Regardless of what you decide, I definitely recommend that you establish something in order to protect yourself and your family. If you are interested in making sure that you are protecting yourself and your family, I definitely recommend that you reach out to me, because one of the services that I offer in conjunction with credit restoration and a whole lot of other credit educational services and debt management services is living trust and will preparation. And if you've done any research for this, you may understand that this can cost you thousands and thousands of dollars in the marketplace. However, you can get access to full preparation of these documents for a mere fraction of the cost, and it's actually included in our services if you are in need of credit restoration too. If you just need a will or a trust preparation separately, we can also do that for you. So definitely feel free to reach out to me if you need assistance with that. And hopefully you got a lot of value out of the video. Make sure to like, comment, and subscribe on the video. And until next time, I look forward to connecting with you very, very soon. Take care. Bye-bye.